Officer Day, would you open the courtroom for us, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Good morning, Councilman.
Good morning, Your Honor. How are you today?
I'm good. How about yourself?
Good, thank you.
What do you have today?
I have 817, and I did submit a response, but I got it on Friday, so the court doesn't have it yet. I checked the ROA. Do you want me to email it or fax it so you have it?
Just do it orally.
Okay.
817. Okay. All right. I have a couple of phone numbers here. Let me see who these people are. Hello?
Yes,
What is your name?
Bernard Webster.
I'm sorry, Bernard Webster?
Yes,
All right, so you're 128121. All right, Mr. Webster, I'll put you back in the waiting room.
thank you.
Hello? Hello?
Yes,
What is your name?
I'm David. Yes, will you stop? Stop! This is David Green, Kevin Green's brother.
Not time for this shit. Okay, I don't seem to have an appointment for you, Ms. Nunes. Back to the waiting room.
Thanks.
Hi, Your Honor.
Are you on somewhere else?
No, I got the defendants on my phone and I'm trying to direct them to the court website to click your virtual courtroom right now.
What file do you have?
I have 010.
010 American Lending versus Arnold.
Yeah.
Okay, I'll put you back in the waiting room.
Okay, I'm gonna get them logged on for you.
We'll see.
Okay.
Counsel,
Good morning, Your Honor. Can you hear me okay?
I can hear and see you. Nice suit. What are you here today for, sir?
Automobile Club of Michigan versus Bernard Webster for the plaintiff, Your Honor.
I have Mr. Webster,
Perfect.
believe it or not, so we can actually get started. Hello?
Yes,
What is your name?
Bernard Webster.
Talk more closely to the microphone. This is file number 22187308, Automobile Club of Michigan versus Bernard Webster, date and time for pretrial appearances.
Good morning, Your Honor. Joshua Kosmerick, P80941 for the plaintiff.
And your name is again, sir?
Bernard Webster.
All right. Where are we on this file, gentlemen?
Your Honor, we had a first pretrial in this matter on October 6th of last year, at which time the court entered a discovery order. Discovery was issued by the plaintiff on October 7th. Hasn't been responded to yet. There was a second pretrial on November 3rd. Defendant had filed the dispositive motion, which the court heard and denied on December 1st of last year.
Correct.
So I believe this is just a status conference to see where the parties are at. I think at this time, if we could just get a settlement conference date and a date at which time plaintiff could file and have its motion for summary disposition heard, I think that could help move the case along.
Well, let me ask here, Mr. Webster, is it your intention to do any written discovery in this matter?
No,
No?
no.
Okay. Mr. Kazmarek, are you completed with yours?
Yes, Your Honor.
Written discovery is closed. Easily resolved problem. Mr. Kazmarek, your office has submitted a proposed default against defendant one, Donde Walton.
Yes, Your Honor.
I did not see an SCRA status report. Oh, here it is from Mr. Walton. Okay, I see it. We can enter that default today. Now, in regard to your claim, have you gentlemen discussed resolution?
No.
We have not, Your Honor.
All right, so what I'm going to do is I'm going to close your discovery today. I'll give you one more pretrial date. That will be February 8th at 10 o'clock. Does that work for everybody?
Yes.
Yes, Your Honor.
Now, what I'm going to do now is I'm going to put you gentlemen into a chat room. If you can resolve the file, come back to me. If you don't, I'll see you February 8th at 10 o'clock. Your discovery is closed as of now. I will send out the default co-defendant Walton on today.
Thank you, Your Honor.
All right, gentlemen, let's get you to breakout room, see if we can't get this file settled.
Thank you.
We are on the record. This is file number 22 193-010. The file is entitled American Lending and Finance versus Edward Allen Arnold. Your appearances.
Good morning, Your Honor. Robert Zelinski on behalf of plaintiff P 69250.
What is your name, sir? What is your name, sir? You hadn't caught up to audio yet. What is your name, sir?
Edward Allen Arnold.
All right, let's call your case again now that you have audio. This is file 22-193010, American Lending and Financial versus Edward Allen Arnold. Where are we on this file, people?
Well, Your Honor, we talked in a breakout room in the first pretrial. Mr. Arnold was going to talk to the other signatory to the contract and call me back and discuss the matter. He never did. I went ahead and filed a motion for summary, Judge. I put it up for this date. I don't know if you want to hear that or where we're going with that, but I did file that just to be heard at some point if needed.
Yeah, I have your motion, counsel, but I calendar motions for summary disposition. And typically I do not calendar a C10 motion until discovery is complete.
Right.
Because the answer is always what? Discovery incomplete. So it's a waste of everybody's time.
Right. So anyway, I got it on file if needed in the future, but we haven't spoken. I didn't submit any discovery because I felt that my client didn't need anything. So that's where we're at.
Mr. Arnold, are you intending to do any written discovery here?
Your Honor, I have been looking, but trying to get her to talk to the lawyer, but she hasn't got back with me.
Okay, let's stop right here, Mr. Arnold. I need you to answer my question right now. I'm asking you, are you intending to do any written discovery in this case?
What do it mean, Your Honor? I'm not understanding the question.
Written discovery is your opportunity to learn about the claims and defenses of the other side. It includes such things as requests for admissions, written interrogatories to be answered under oath, and requests for production of documents. It's an opportunity for you to know what the claim is of the other side. Are you intending to do that or not, sir?
No.
Okay.
But I don't know.
Well, sir, I can't represent you. If you want to represent yourself, as is your constitutional right, you can do that, but the court cannot give you legal advice. So what I would urge you to do would be to get a lawyer. That's up to you. This is what I'm going to do. I'm going to give you folks one more pretrial in this matter. And if you get a lawyer to appear for you, have the lawyer file the appearance. The appearance is a document by which the lawyer says he or she will represent you. Otherwise, we're going to have to move forward with this file. Our next date on this case will be February 8th at 10 o'clock. Does that work for everybody? It's a Wednesday like today.
Yeah. Yes.
Okay, Mr. Zelinski?
That's for works, Judge. If I could just, as I got Mr. Allen here or Arnold here, urge him to call me. We can discuss the matter if he
No,
wants.
I don't even need to do that. I'm gonna put you guys in the chat room and you can talk right now. Nobody
Okay.
have to worry about calling anybody. I'll put you in the chat room. If you settle the case, come back to me. I don't think you will, but if you do, come back. Otherwise, February 8th at 10 o'clock.
Okay,
You guys into a chat room right now, and you can discuss the file right now.
sounds good, Judge. Thanks.
Thank you.
All right, let's see. Let's get you in the chat room. How about 2? This is 3. Assigned to room 2. Okay.
I'm waiting on. Say 2.
Join break room.
Yeah.
Where it says join. Mr. Thibodeau, good morning. Hello? Hello?
Good morning.
What file do you have, Mr. Thibodeau?
I have, it looks like 652, Velocity v. Renee Neal,
And who are you representing?
the defendant.
Okay, I think I have Mr. Johnson, so we can get you guys started.
Okay.
Okay, we are on the record with file 22-195652. Velocity Investment versus Renee Neal. Your appearances.
Good morning, Your Honor. Brad Johnson, P75416 on behalf of the plaintiff.
Good morning, Matthew Thibodeau, P72632, appearing on behalf of the defendant.
And you guys came in and told me you settled the case.
I think we're getting there. Defendant just served their responses to our discovery.
Okay,
I'm good with proceeding. If they don't need any more discovery from us, I'm good with just maybe getting a scheduling order for a motion for summary disposition.
Mr. Thibodeau, you need any written discovery?
No, no, we can just get a date. That would be great.
Okay, so you guys both want me to close your discovery.
Well,
All right, let's give it another day.
okay,
Let's give it one more day. And we'll see you guys in again, February the 8th at 10 o'clock. Remind me then that I'm closing your discovery and I'll set the case for summary disposition date at that time.
Perfect.
You guys
Okay.
need to talk or you need to go do other things?
I think we're good.
Okay, February 8th, gentlemen, 10 o'clock. I'll close your written discovery on February 7th. How's that?
Very good.
That work for
Sounds good.
everybody?
Thank you.
Let's be safe out there. Thanks
All
for
right,
coming.
thanks. Bye-bye.
You as well.
Off the record.
Bye.
Ms. Winters? Ms. Winters, good morning.
Good morning, Your Honor. How are you?
Good. How about yourself?
Good. Happy New Year.
And the same to you. I do not have your opponent as of yet.
Okay.
I assume you're here on the Oakland County versus Tanisha Smith matter?
Yes, I am.
Yeah, okay. I don't have her as of yet. Put you back in the waiting room.
Sounds good. See you in a
Thanks.
few. All right. Bye-bye.
Hello?
Good morning.
What is your name?
Kimberly Nicole Anderson Key.
Hold on, please. We are on the record. This is case 12113-817. Mouth working, sorry, let's try it again. LVNV Funding versus Kimberly Anderson. Date and time for objection and garnishment. Your appearances.
Good morning, Your Honor. Attorney Ashley Nonis on behalf of plaintiff P77029.
And tell me your name, ma'am.
Kimberly Nicole Anderson Key.
You are the moving party. What is the basis of your objection and garnishment?
The basis is the balance has been paid in full with the fees, and it done waited over the 10 years, and they just coming after me, which they've been doing for years. I've been sending out a letter saying it been granted, but they giving me trickery letter saying it must be another account. It was my fault. One time I sent in a letter, but I didn't mark it off saying I'm sending in a letter, but I addressed the letter as well as sent in my garnishment letter. No, excuse me, my judgment letter, a copy of it. And they just still, it was due to my sister. She was a second card holder. But I never be late on any of my bills. They just going after my credit.
Ma'am, is there anything else you want to tell the court?
I hope you grant this due to I paid it off and had been sending it and saying, please seal this because I don't owe you anything. They went after the balance. I was granted a little bit over 4,000. She spent 15,000, and then with the fees, it came up to $1,776.69 to Bank of America. I don't know these people. It was paid, but they saying, well, whoever I paid it to, but I paid it to Bank of America, and so I'm hoping they can seal. I hope you grant this. Thank you. I apologize.
Ms. Nonis.
Thank you, Your Honor. I did submit a response on the 6th that attached a ledger that clearly shows that this is not paid off. The defendant also does not provide any information, excuse me, to substantiate her claim that this was paid. She attached nothing to her motion. I don't see anything in the file that she's ever sent us for proof of payment. And according to our records, there's still a balance owed. The current balance is $5,091.65, and that's reflected in the ledger that I sent her as well.
Who is the original creditor here?
The original creditor was Bank of America.
Yeah, okay.
And I have placement information. The account was opened in 2004. The last payment on the account was 2013, which was post charge off, as the charge off date was 06, and then a judgment was entered in 12. So it looks like after the judgment, there were also payments made.
All right. Of course, prepared to rule in this matter. I am looking, Ms. Anderson, at what you provided, and what you provided to support your claim was a letter from National Credit Service Systems Incorporated concerning a debt had been satisfied, but it describes a client as Landings at Chandler Crossings, not Bank of America. Looking at the register of action in this matter, defendant was personally served with summons and complaint on August 14th, 2012. The judgment was renewed October 11th, 2022. You have failed, ma'am, to state a valid objection to garnishment. Objection to garnishment may not be used to attack the validity of the underlying judgment. Having failed to state a valid objection to garnishment, your objection to garnishment must be denied. You, of course, ma'am, have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. The court will send out to both of you a copy of the order denying the objection to garnishment. Thank you both for coming in. We are off the record.
Have a good day, Your Honor.
You too. What is your name, sir? You gotta be kidding me. Hello? Hello?
Yes, yes.
What is your name?
This is no, this is David Green. I'm calling for Kevin Green. Sir, I'm not talking about the case. I didn't call to talk about it, but he's having an episode. Could we adjourn this? Could we, I've been going on with this for about 2 hours now.
Mr. Chisholm?
Judge, I'm gonna leave this to your discretion.
I'm sick of people trying to take it back. I spent $20,000 already on the car that didn't even work, $2,000.
All right, let me have your, excuse me. Tell me to be quiet.
Hello, yes.
Tell me to be quiet.
Right. You got to be quiet. You got to go. Just go in your room. Go in your room. Go in your room. Go in your room.
We are on the record calling file number 22-190-626, Reliable Auto Finance versus Kevin Green. This is the date and time set for hearing on the motion for summary disposition filed on behalf of Reliable Auto Finance. Apparently, the defendant is having some sort of episode. We really are not in position to proceed at this time. Could I have your appearance, counsel?
Good morning, Your Honor. Jeremy Chisholm, P74670. I'm the attorney of record for the plaintiff.
All right, Mr. Chisholm, I'm going to adjourn this matter for 1 week. Does that date and time work for you?
Judge, I believe so. You're going to do it 10 o'clock
Yes, sir.
on
Like
the
today.
18th? Is that what you're thinking? Okay.
Yes, sir.
Judge, I have 4 in-person hearings at 10:30 that morning.
Then let's do it another day.
Would the 25th work for the court?
All right. We'll do it on
the 25th is wide open for me, Judge.
All right. Okay, I'm going to unmute the other line. Okay, we're going to adjourn this matter using the court's discretion to January the 25th. There will be no further adjournments. We'll send out an order today.
Thank you, Your Honor.
Thank you for your kindness, sir.
Thank you.
We're off the record. We are on the record calling case number 16114-997, Oakland Community College versus Tanisha Smith. This is the date and time set for an objection to garnishment. Objection to garnishment scheduled at 10 o'clock. It's now after 10:30. Could I have your appearance?
Yes, Your Honor, Susan Winters appearing on behalf of the plaintiff, Oakland Community College,
Bar number.
P 41153.
The defendant has failed to appear. Her stated ground for objection is that she has an installment order dated 11/18/22. And she says the writ was not properly served because never sent papers, been to 36th District Court to get some paperwork and calling attorney for 3 months. I have a response on behalf of Ms. Winters, which indicates the judgment has not been satisfied and no documents, and there's no indication that there's an installment payment plan being barring garnishment in this matter. Looking at the register of action, there was a prior installment payment plan that was set aside, it looks like, back on May 4th of 2017. Since that time, the court granted installment payment, it appears, on November 18th, 2022. Then thereafter, the objection to garnishment was filed. Ms. Winters?
Your Honor, our office received the defendant's motion for partial payments, and we filed an objection. And we asked that the court enter the order for a larger payment amount. And after that, we never heard anything. We didn't get a copy of any type of order or anything from the court with regard to the partial payment order. So we didn't know that an order had been entered. And so when we started to receive money from the garnishment, we kept it because we didn't know that there's an order with the court. So when Mr. Cox in my office did this response to the objections to the garnishment, he found in the register of actions that there was this, the order. So we just didn't know about it. And what our position was is that we felt that the defendant was in a position to pay more than $50 every 2 weeks. And we would have argued that we were looking for $100 every 2 weeks. But in any event, she hasn't made any $50 payments. And so we will return money to her, but I was hoping that maybe when she was here, with the court, that we could have a larger amount, in the payment order.
Well, I'm not going to modify an order that the court issued that apparently your office, for whatever reason, did not comply with. So what I'm going to do is I'm going to grant her objection to garnishment. You're garnishing her employer, and we entered an installment payment order, which obviously is aimed at protecting wages from garnishment.
Yeah, if we had received it, we would have returned the money, Your Honor. We just didn't know.
We'll send
We
it
didn't
out.
get a copy of it.
Thanks, Ms. Winters.
Okay,
Have
we'll
a good
get her
day.
money back. All right.
Thank you.
All right. Have a good day. Bye-bye.
Bye-bye. What is your name, sir?
Kenneth Davis.
We are on the record, 191580002, Fifth Third Bank versus Kenneth Davis. Date and time for objections and garnishment. Matter scheduled at 10 o'clock. It's now after 10:30. Mr. Davis, what is the basis of your objection and garnishment?
Well, they actually what they did was they came in and they immediately did a freeze on my account. Now, I don't have a problem with them taking money. However, they didn't do an evaluation of what my wages were. I mean, I owe other bills, sir. I got a car note, and they just put a total freeze on my whole on my accounts, the 3 accounts, because they are a part of the they're a part of Fifth Third. So I wasn't aware of that, and had I known that, I would not have left money in those accounts. But I'm not disputing them taking, the money, what they're possibly owed. My thing is do an evaluation of what my wages are and what my bills are. Then feel free to take whatever you got to take. I don't have a problem with that. But don't just take all my money and I got bills. It was during the holiday, Christmas, and that was a time that they just really caught me at a bad time. But again, it's not an issue of them taking the money. I mean, I owe it, but at least do an evaluation of what my wages are and what my bills are, then take what you got to take.
What money was taken from you?
They froze I had like 800. I had like, I had 1,000 total.
They took money out of the bank.
Yeah, yes, money out of my bank.
Okay. Well, let me make sure you understand how this works. A judgment was entered against you in this matter in June of 2019. One of the ways that the judgment creditor, the plaintiff, can satisfy that judgment is by going after money in the bank. There is no limit under the law to the amount of money that can be seized from a bank account. There are limits to money that can be taken from wages. That's set by federal law, no more than 25% of the gross. But since they took the money out of the bank account, there's no limit here. If you do not have an order for installment payments that was entered on March the 10th, what the order, because that was set aside when you didn't honor it on May 24th of 22. The order for installment payments, even if you had one, only provides protection for wages. It does not provide protection against a bank account being seized.
Okay, but my wages are in my bank account.
No, sir. It prohibits them from going to your employer, not in a bank account.
Okay, well that's fine. Okay, but they didn't do that. That's fine. If they did that.
You said they took the money from a bank account. That's what you said.
Okay, but sir, wouldn't that be the proper way to go through the employee to see what wages?
Sir, as the defendant, you are not in a position to tell the creditor that you owe money to how they should get the money. That is not your right. The court had previously entered at your request an order for installment payments, which you did not honor and which was set aside.
No, sir. What I put that in for was the amount, not the installment payment. I filed a motion for the amount, and you said that, okay, well, since the amount, I owe the amount, so I said, okay. So the installment payment should have started back, sir.
Sir, that is not true. That is factually inaccurate. To be charitable. To be less than charitable, sir. It's a falsehood.
Sir,
I am looking, don't interrupt me again. I am looking at your request dated February 22nd, 2022. I'm looking at your handwritten request for installment payments where you asked I asked this court for an order installment payments in the amount of $125 per month starting 2/22/22. My order entered on March 10th, 2022 was for $125 every month starting March 30th. The exact amount you had requested, starting later than you had requested. Subsequently to that, in May of 2022, when you failed to make the payments you had requested, the order for installment payments was set aside.
Sir, if I
The
may,
objection to garnishment, sir, is going to be denied. You have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. I'll take a look at your order for installment payments. But again, you're asking for the same matter that was set aside that you failed to comply with last time.
may I speak, sir, please?
Yes, you may.
Okay, sir, and again, I apologize. That motion was wrongly filed in the wrong manner, because what I was filing that motion for was for the amount. I never disputed the amount of the installment payments. I could afford that. What I filed the motion, so that was my, not because you're right. That was, I went about it, I filed the wrong, in a wrong order. What I was doing was disputing the amount. So because $125, sir, wasn't a problem. I could, I could afford that. That wasn't the, so I apologize. It was just worded wrong. And you are right. That is what I submitted. And when I tried to explain that I just had a problem with the amount, because we had entered in for a half of what the original. So that's what I was disputing, not the $125. So again, I apologize for that, and that was my fault for miswording how that went. But sir, I can afford the $125. That's not a problem. And if I could get that back, it's just I would pay it. I mean, that's not a problem. The $125. I was disputing the amount because they had offered a settlement, and the settlement was for $2,500. And when I tried to explain that, yeah, you was a little upset. I understand. I was having issues with the virtual thing. It took us like 3 different times. So I kind of saw you was a bit frustrated. So that kind of, I know that can, but sir, again, moving forward, that was the only problem. It was the dispute of the amount, because they had settled for $2,500, and that's what the emotion was for, so that I could keep.
That's not the motion you filed.
Right, I agree.
That may have been what you intended. That is not the motion that you filed.
Okay, I do agree, sir. I
decided the motion you filed and granted the relief you requested.
Yep, and that was God. That was foolish.
Then you did not honor that faith.
Okay, that was bad on my part, and I do apologize. And I was so upset when I saw what it was, because I'm like, oh wow, I'm not disputing the amount of payments. I can make the payments. It was, I didn't want to pay the $4,000 because they entered a settlement, and the only reason I didn't fulfill this stop because of COVID. And nobody,
let me make sure I understand this.
Yeah,
you had offered a settlement, and you didn't meet the terms of the settlement. Is that right?
Right, because of COVID.
All right, so let's stop right here.
Yeah, because okay.
Listen, Mr. Davis, think what you're saying.
Okay.
You're claiming that you're entitled to a settlement that you agree you did not make the terms of. Mr. Davis, I'm going to deny your objection to garnishment. I'm going to look at you want to do the 125?
Yes, I do the 125.
All right, I'll enter that order to that regard, sir. Thank you for coming in.
Okay, thank you.
We're off the record.
Okay, thank you.
Crying out loud. Put this on. Stop video. Turn on video. Stop this.
Morning, Your Honor.
Good morning.
David Rosenberg here, sir.
All right, we are on the record. This is file number 221903996. The file is entitled Jordan Irby versus Keys Auto Sales. Two matters before the court today. Plaintiff's motion for entry of default judgment. Defendant's motion to set aside the default. Your appearances.
Plaintiff first, Your Honor.
Go ahead.
If I may, David Rosenberg, Your Honor, P27407, on behalf of the defendant Keys Auto Sales.
What is your name, sir?
Jordan Irby.
All right, there are two motions here today. We're going to start with the defendant's motion to set aside the default, because if the court grants that, there can be no default judgment and the other motion would be moot. Let's hear from Mr. Rosenberg, his motion.
Thank you, Your Honor. I believe, except for a couple of Scrivener's errors in the body of my motion, what I'm attempting to make clear to the court is that two things. Service, well, number one, was improper according to the court rules, and two, if the court understands my argument with regard to service on private corporations or limited liability companies, service wasn't perfected. There is not necessarily a requirement that the defendant supply an affidavit of fact showing meritorious defense, although two affidavits have been filed in support of that particular defense. I was not privy, Judge, to the machinations as to why, after an answer was filed, it ostensibly appears that the defendant did not appear at a Zoom hearing. I'm at a loss to explain why, except for the press of business. But given the fact that, beg the court's pardon, but given the facts as set forth in defendant's motion, I think that there is both ends of the statute are satisfied. A service was not perfected in accordance with MCR 2.105 SSEC. And second of all, in accordance with the affidavits of Ms. Abraham and Mr. Risk, it appears that this was an as-is sale with all of the state statute and administrative code requirements met with regard to selling a used car, advertising and providing that to the public in the state of Michigan. Judge, I humbly ask the court grant defendant's motion and enter an order setting aside default, if necessary, Judge, allowing an opportunity for a short period of discovery of the filing of motions and proceeding according to the court's wishes. Thank you.
Mr. Irby, what is your response to this motion to set aside the default?
My response to the default is the car that they had sold me, the car was like a bad car that they sold me. And
Hey, let me stop you right here, Mr. Irby. What he's saying is that you did not serve the LLC properly. How did you serve the defendant in this case?
oh, I have a officer that came out there and served
And
them.
served the person in charge of the place where the business was being conducted, correct?
Yes.
Did you do anything else?
No, I had just
Okay.
what I did.
Okay, well, here's the problem. The Michigan Court Rule 2.105D governs the service of process on private corporations, both domestic and foreign. And basically, it requires that you do two things. Number one, that you serve a copy of the summons and complaint on an officer or registered agent. That wasn't done here. You just served the person who was in charge of the office. And yeah, that's one way of doing it. But under Court Rule 2.105D2, that's not enough. Not merely serving the person who's in charge with the of the business. You must also serve a copy of the complaint by registered mail addressed to the principal office of the corporation. As you indicated, that was not done here. given the fact that there is a defect in the service, the court is not going to address Mr. Rosenberg's claims of meritorious defense because the court rule provides, or should I say the case law provides, that a defect in service operates as the meritorious defense under MCR 2.603 so as to justify setting aside the default in this matter. What the court will do is I will grant the motion to set aside the default, finding that the service here was not in accord with the Michigan court rules under MCR 2.105D. What I will do, since Mr. Rosenberg has filed an answer, I will give you gentlemen another pretrial date. I will open your written discovery and we can move on from there. Mr. Irby, I would urge you to get counsel because you're trying to represent yourself. And as this episode today demonstrates, you don't understand the rules. You don't get your own set of rules here. We're not in small claims. You have to follow the court rules. The court rules provide very specific ways that you can serve a corporation. And in this case, you didn't follow those rules. So what I'm going to do is I'm going to give you gentlemen a pretrial. Your pretrial date with me will be February 8th at 11 o'clock. I will open your written discovery. I will send out an order granting the motion to set aside default. Having granted the motion to set aside the default, the motion for entry of default judgment is therefore moot. We'll get you gentlemen on order. We'll see you February the 8th at 11 o'clock.
Thank you very kindly for your time, Judge. It's great seeing you again. Good luck, Judge. Thank you. Good luck, Mr. Irby.
Thank you, sir.
May we leave?
Yeah, I'll let you guys go right now.
Thank you, Judge. Thanks.
Support for double four CJs provided by G or Solar is set in place, operating the new year. When any state money to be always picture of the meal at the end is following nothing. In a romantic program, Schubert drop on Sunday, January 15th at 2 p.m. at the Pop New States Theater, 29,995 Road, Farmington Hills. For tickets, call 586-944-5350. And don't visit Chamber Solar. I'm Bud Sparrow, and you're listening to WRCJ FM and HD 1 Detroit, 90.9, the listener supported service. It's WRCJ FM, with Peter Wolf, with the midday music show, and Wagner to start off this hour. Classic Blue Orchard, Columbia Symphony Orchestra recording. Music from the Wagner Opera Contest. Jim Meistersinger wasn't the only opera about the singing contest. That's part of the thought. This Wagner number too. I think this is a guy who might have been into PGT or was him. He just loved the singing contest. Occidental College Choir is going to do the singing. Walter, vintage report, 1961, WSJ 9.1. We are on the record calling file number 181500401, Johnson Financial Recovery Group versus Ukinda Griffin. On November 23rd, 2022, the court signed a subpoena for the defendant to appear today virtually for a debtor's examination at 11 o'clock. It's now 11:30. Neither the plaintiff or defendant having appeared, the subpoena, the debtor's examination is hereby quashed. The next file we're going to call is file number 22182876. This file is entitled LVNV Funding versus Naisha Notes. On December 1st, 2022, we sent out a notice of hearing for today, January 11th at 11 o'clock on the plaintiff's motion to reinstate the case. It's now after 11:30, neither party having appeared. The motion to dismiss, to